Hey everyone, welcome back to the channel, because today's case is completely unhinged. Judge Washington is not here for games, not here for fake sovereign citizen fairy tales, and absolutely not here for this crane-eating Karen trying to argue her way out of reality. From the moment she opens her mouth, the judge makes it painfully clear that this courtroom operates on facts, not fantasy, and she's about to shut this nonsense down fast and hard.
Mental health. There's something wrong with you. You have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, what did I make up?
Now, some of you might remember I just covered this same Neanderthal Karen, the one whose kids were screaming non-stop in the background like it was a daycare meltdown instead of a courtroom proceeding. Well, today the kids are finally in school. But don't get too comfortable, because the chaos didn't leave with them. Now it's her mother stepping into the spotlight, and Judge Washington is about to hand her the exact same brutal reality check. This time, it's not the kids getting loud, it's the judge. So yeah, let's get into it.
Good morning, the 14B District Court is now in session. My name is Elaine Washington.
I find everyone's very funny but my own. I'm French.
Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anais Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Battle, please unmute and state your name.
Anais Battle, appearing especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today. Battle, when you're not speaking.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battle's direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease. Okay,
that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law and
please
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am, and that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is
Well,
not.
that sounds prejudiced and biased because I'm not a sovereign citizen. So
All right, listen. If it walks like a duck, talks like a duck, and files paperwork like a confused Facebook lawyer, then congratulations, you've got yourself another glue-sniffing sovereign citizen. Just like I explained in the last video, her entire defense is built on this so-called constructive eviction claim. She's trying to argue that the property became unlivable, so she had the right to walk away from the lease with zero consequences. Here's the problem, you don't get to scream constructive eviction while you're still living there like nothing happened. The moment you stay, that argument dies, because you clearly weren't forced out. No matter how hard she tries to dress it up in legal-sounding nonsense, the court sees straight
You're using as your basis is still not correct. It is not the law.
it is. It's still under
It's
MCL
not
and it's under the Landlord-Tenant Act.
overruled.
My objection is overruled, Your Honor.
No, the objection is sustained. Her question, it cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was
Because
rescinded?
that's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
My ruling, I'm not arguing with you anymore about it.
right, it's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to
Ma'am,
asking these
please
questions.
move
I will
on.
continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there a proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You cited a statute that I actually need to look at. MCL what?
I'm sorry?
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.
I absolutely love it when these people start citing the law with full confidence, because half the time it backfires instantly. And in this case, the attorney is actually 100% correct. Under MCL 600.5716, the property manager has to serve a proper demand for possession before the landlord can even start the eviction process. So while she's sitting there acting like she cracked the legal code, she's really proving two things at once. She has no idea what she's talking about, and she clearly didn't even read the statute she's trying to flex.
The question I asked next, once he said that the
But I
demand for
wanted to
possession.
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add, her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's now, again, she's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay, that's fine. I didn't cite an exact statute, but I appreciate your...
Kids, seriously, don't do drugs, because apparently they'll have you forgetting what you said 1 minute and 58 seconds ago, like your brain just hit the reset button. This is that special kind of confident nonsense where someone contradicts themselves in real time and still acts like they're winning. Since her memory is clearly on airplane mode, let's refresh the record real quick. What statute did you cite? MCL 600.5716. I mean, 57.6. No, 600.5716. Yeah. Exactly.
I just said MCL because they're both under NCLs. Both proof of service and certificate of service are both under MCL.
No.
All right, well, everybody. So let's not make my ruling.
Let's just. Okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service.
Okay.
Is not on the disposition, and just like she read on 657:16, was the property described on that disposition?
Yeah.
Was there a description of the property?
Yes.
There was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no such grievance procedures under this. Anything that I'm aware of. I mean, I don't even know what she has a grievance about.
Right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
No, we're not publicly.
Well, you accept HUD housing. You accept HUD housing, and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
Object to what? I didn't say anything yet.
Well, I'm objecting because she asked Miss Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next question.
And she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth before you objected me.
Let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
just say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't, because it's not. That is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor, again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded. So let's be clear.
Just
I said either federally funded or get federal funds, which you do if you accept section.
Sure, and that might actually be true in HUD-related eviction cases, where specific federal rules and procedures apply. But here's the part she keeps missing while she's running her mouth on the record: this genius isn't even receiving HUD assistance. So all that HUD law she's trying to weaponize? Completely irrelevant. It doesn't matter what she thinks she knows or what she Googled at 2 in the morning. If she's not in HUD housing, those statutes don't apply to her case at all. And the court is about to make that painfully clear.
Yes, it is correct. Because if you received any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are. Do you?
I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Ms. Battle does not receive a voucher, and all of this questioning.
Well, it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that, how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a federal registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD says that these are the requirements, hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind any.
No, you're absolutely getting a fair hearing. The problem is you're refusing to accept the part where you're dead wrong, and you're not even smart enough to understand why. Here's the reality check: it is not the court's job to babysit your ignorance or reward your confusion with a lifetime of free rent. Your failure to comprehend the law doesn't magically turn into a legal defense, and it definitely doesn't make the landlord responsible for funding your delusions.
Move on.
Move on. So, okay. Do you have a copy of the court establishing jurisdiction?
Who's that a question for?
Dawn, my plaintiff.
Your Honor, I object. The court's already said they have jurisdiction over the property.
The court said that she got jurisdiction because she said so, and that's non-judicial.
Okay. Ms. Battle, move on.
Move on to what? This is not a fair hearing. And again, this is why
you're trying to turn this into.
I'm not trying to turn it into anything. I'm just trying to state the laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts. But for some reason are hindering me in this proceeding. And that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with all of you all, because this is just not. And I told the Attorney General, and I told the IRS, and I did everything else because at the end of the day,
please move
all
on.
this is not right. And Attorney
I'm going to be filing criminal proceedings against you for all these frivolous things that you're filing.
Oh, damn! Now that is not something you hear every day. Judges usually keep it polite, but Judge Washington straight up tells this window licker she's staring down potential criminal charges for running the same copy-paste sovereign citizen script and clogging up the system with frivolous federal filings. And the way the judge leans into it, you can tell she's done playing nice. Trust me, you know my team and I always go the extra mile to bring you the full story, and I've got a special surprise waiting for you at the end of this video, so make sure you stick around.
Not my rights, and my rights are not frivolous.
Please move on.
It's honestly, if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut, that would constitute as
cross-examination.
If you're not going to ask appropriate questions, then I'm just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't have a real opportunity to ask the questions. So at this point, like I said, I'm just going to have to get the federal court involved and get the marshals, because I don't know what you...
Yes, you do, because let's be honest, this probably isn't your first attempt at scamming your way into free rent. Now she's sitting there talking about how the marshals are going to get involved like it's some kind of power move. But I hate to piss in your paint chips, sweetheart, it won't be the marshals. It'll be the sheriff. And they're not showing up to negotiate. They're showing up to put you out so the property can be repossessed. And right here is where Judge Washington finally hits her limit, gets sick of the nonsense, and tells her exactly what she thinks of her.
And with good faith. So I don't know. I'm stuck on what to do. The integrity of the court is questioned.
With you. I don't know what that is, but you should seek some mental health. Because something's wrong with you. You have You have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be specific. No, be specific, because now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
All right.
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action. And I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection. Oh, because you're saying that because a notice was given and unrebutted.
Frivolous motion doesn't magically become valid. It's still frivolous and still has zero legal foundation, no matter how loudly someone insists otherwise. I already know people are going to jump in saying the judge should know exactly what to do, but the funny part is, she does. This is strategy. She's building the record and essentially cueing the complaining attorney to make the next clean move, asking for a directed verdict so the court can shut this nonsense down the right way, the legal way, and without giving the other side anything to twist later.
Right?
Yes, that's not the law.
It is. It's the law. It's Wells versus Zendaya of Michigan. It is. It's
all right.
It's backed in case law, and y'all keep muting. It's okay, because he can talk, but I can't talk.
Ma'am, you've argued that over and over, and I've ruled that it's not. You can file your appeals, file all the things you're filing, but when you file false liens against people, that is a crime.
It's not a false lien. You got defaulted on a private side, and you know that.
Okay, whatever. All right,
Yeah,
so
well,
what I'm going to do is grant your judgment in this particular case because I've given her an opportunity to present the defenses that are real, and she has refused to do that.
I didn't refuse to prevent defenses. You didn't ask me about my piece of the case. I only got to cross-examine. You didn't ask me about my defenses.
What are your defenses, ma'am? And rescission is not one. I've ruled that it's not.
I'm sorry?
I know you heard me.
No, I didn't. You said, what are your defenses? And I didn't hear the last piece.
Your rescission is not a defense.
Okay, that's fine.
That is your defense.
Right, because, you know, threshold matters are not an issue. But again, like I said, the fundamental objections and a counterclaim, object to the subject matter jurisdiction. You all accept and receive housing funds, making the subject
We're
matter.
going down the same road.
Okay, listen, stop. I didn't cut you off. I didn't cut y'all off. You just asked me what my defense was. And
all right, I'm done.
wow. You're asking me what my defense is. I can't.
Take her out. I've asked her 3 times to stop this. All right, I'm going to grant your judgment in this particular case.
Your Honor, are you going to check the box after hearing?
Yes.
Thank you.
Thank you.
I'm sorry.
Thank you, Judge Washington.
I'm sorry you had to go through that.
All right, thank you.
Thanks.
Appreciate it. Bye.
Right, guys, that's the end of the video. And there you have it. Judge Washington ruled against her, and the self-proclaimed Mother of the Year just turned her own kids' lives into collateral damage. All because she chose ego, internet fairy tales, and sovereign citizen nonsense over basic common sense. You'd think protecting her children would come first, but clearly she only cares about one person in this story, herself. Like the video, subscribe to the channel, and I'll see you in the next one.